Welcome, everyone. I am Richard Rifkin. I'm the legal director of the Government Law Center. And we welcome you to the third of the programs that we've presented. These programs are presented by the Government Law Center at Albany Law School, and they are sponsored and funded by the Community Foundation of Oneida and Herkimer counties. And we very much appreciate the support of the Community Foundation in helping us present these programs. The programs really, given the onset of COVID-19, we've focused them on the concerns and needs of small businesses that are struggling now to make it through the restrictions under which we all exist. We've had two previous programs. This is the third. The first of the programs was on insurance needs of businesses. And the second one last month was dealt with issues in the area of bankruptcy. And these were recorded, by the way, and are available on the website of the Government Law Center. Today, we're going to focus on labor issues. Let me add, before we get into the presentation, that one of the things that we're trying to do is assist small businesses in the two counties, Oneida and Herkimer counties, in getting legal assistance if they have specific questions they need help with. This is part of the service we're trying to provide. And I would say that anyone who has a specific legal question on which they're seeking help on a pro bono basis from a lawyer, please send an email with your question. And I'll give you the email address: glc.albanylaw.edu. That's glc.albanylaw, that's one word, .edu. If you send a question to this address, we will endeavor to find you some legal assistance for a specific question. This is free legal assistance we're talking about, so it's limited. If you're looking for more comprehensive legal assistance, we would urge you to go to a lawyer referral service, and there is one, if you need one, at the New York State Bar Association. So for today, our speaker is Paul Breiler from Bond, Schoeneck & King. He specializes in labor law, not surprisingly. His work at the firm includes both transactional work, that is dealing with contracts and issues that come up with contracts, as well as litigation in the labor field. We've included his biography and in the materials that have been sent to each of you, so I'm not going to spend time going over his entire biography. You can find it there. And with that introduction, let me turn the program over to Paul.
All right. Well, thank you guys so much for the warm welcome, and thanks for the opportunity to speak to everyone today. I guess we'll get started.
You're ready? I think we're ready to get started.
Okay, so I know you guys have my bio. I've also included here just my contact information. If you have questions throughout the presentation, please, either jump in, ask your question, or feel free to type your question into the chat. I'll try to answer as many as I can as we go along. I'll leave a few minutes at the end as well. But if something occurs to you tomorrow, a week from now, whatever, something that you think is something that you heard in the presentation, you'd like to know more about, feel free to just give me a call or an email. I'm happy to answer one-off questions, and of course, feel free to go through the Government Law Center if you have something that is a little larger and you feel that you need a pro bono attorney as well. We're going to do our best to cover a bunch of topics that I think are most pressing to you guys as small businesses. One thing that I do want to mention at the outset that we are not going to cover, and this is just a function of the fact that I feel like it's been out for a long time and I'm not in my practice getting a lot of questions about this, but feel free to ask questions about it, is the New York reopening guidance. So this was something that we saw come out in June of 2020. There was a flurry of putting together reopening plans for businesses that had been working remotely and wanted to reopen their physical office space. At this point, I'll be honest with you, I haven't helped a company with a reopening plan in well over 6 months, because it was a very quick flurry. So if you have questions about those, feel free to type in the chat or interject. I'm happy to answer them, but it's not a topic that I wanted to delve into deeply today, because I just think it's not something that businesses are dealing with as frequently now. So at the outset, I wanted to go over New York generally applicable sick leave law. This is something that we saw come out of coronavirus, but isn't necessarily specific to coronavirus. And we'll talk about some of the more specific COVID leave statutes in a few minutes. But, if you were tracking, if you're one of those people that follows, the budget every year, you would have seen that in the budget that came out in April of 2020, Governor Cuomo proposed a generally applicable sick leave law, applies to all employers in New York State. It basically became effective at the end of September, but didn't allow people to use sick time until January of 2020. So we'll kind of talk about, what the sick leave law means and, what its impact is on you guys. So first off, I wanted to mention that this applies to basically all employees. It doesn't matter if they're part-time, it doesn't matter if they're full-time, it doesn't matter if they're per diem or temporary employees. If you have an employee, they are entitled to some amount of sick time, irrespective of their status or specific classification, as long as they're an employee. So this doesn't include people like independent contractors. This doesn't include vendors that you might have coming in and out of your office. But anyone who is, actually on your payroll is going to be entitled to some amount of sick leave, and they can use it as soon as they've earned it, basically. So under the law, became effective September 30th. That's when people started to accrue leave, and then they could start using it January 1st. Now, if anyone has, any quantity of sick leave and they have a qualifying reason, and we'll talk about the qualifying reasons people can take sick leave, but if they have time, they have a qualifying reason, they can take it basically immediately. So there's two ways that your employees can actually acquire sick leave. So they can accrue it over time, or it can be front loaded. So what you can do, and this is totally your prerogative, how you want to handle this, you can pick a 12-month period. It can be any 12-month period that you want to be your year for purposes of the paid sick leave law. And at the first day of that year, you can front load people, either the full amount that they could possibly accrue, or what you anticipate to be their accrual amount over the next 12 months. So what you can do, let's say you have a full-time employee and you're supposed to allow them to accrue 40 hours of sick leave over the course of the year. You can give them a full 40 right now, January 1st, whatever the first day of your year is. The alternative is that you can have them accrue sick leave over time. It accrues at a rate of 1 hour for every 30 that is worked. And so what that effectively means, let's say you have a full-time worker, they work 40 hours a week. Over the course of that week, they're going to work 40 hours. That means they get 1 hour for the first 30, 1 hour of PSL, and then they're going to get another 20 minutes for that extra 10 hours that they've worked in that week. So over the course of a week, a full-time employee is going to accrue 1 hour and 20 minutes of sick leave time. And again, this accrual begins either September 30th of 2020 or the first day that you actually employed them. And so if you haven't done this yet and you want to provide people with sick leave based on an accrual method, what you can do is look back at the hours that they've worked between now and September 30th of last year, tally up that total, divide by 30, and that's the amount of sick leave that your employee should have based on the number of hours that they've worked over the last several months. Okay, so the sick leave law also requires certain carryover and termination. It basically says that all sick leave that hasn't been used in whatever your year is that you've chosen, whether it's a calendar year or some other 12-month period, it has to carry over to the following year. but you can put caps on the amount that employees can use. So, you guys are small businesses. I'm going to assume that you have fewer than 100 employees. That means you can cap people's use of sick leave in any 12-month period at 40 hours. Larger employers who have over, 100 or more employees, they have to allow at least 56 hours of use every year. The other good thing for you guys is that if you put this in your sick leave policy, you don't have to pay out accrued sick leave when someone leaves or is fired. So that means, even if they had accrued time that they didn't use, as long as you put this in your policy, you don't have to pay it out on termination, even if you pay out other forms of PTO, vacation, or anything like that. The other thing I should mention, this is a New York state law requirement. You have to provide sick leave. There's another New York state law that says if you provide any form of paid time off, you have to put that policy in writing and have it available to your employees. So just as a general PSA, I strongly recommend that all of you, if you haven't done it already, put together a paid sick leave policy. It doesn't need to be extensive. Some of the things that we're doing for our clients, it's a 2-page policy, just outlining the basic requirements that I'm talking about here. Selecting a few of the options of how you want to handle it, things like front loading versus accrual, if you want to impose any caps on use, things like that. So I strongly recommend all of you, if you haven't done it already, put together a paid sick leave policy. Okay, so this is probably the best news for you guys. The amount of leave and whether it's paid or not depends on both your size and your net income in any given calendar year. So a lot of you guys are small businesses. You may have 4 or fewer employees. If that's the case, you only have to provide 40 hours of sick leave. The one caveat there is for some of you, it could be unpaid leave, and for some of you, it may be paid leave. So for those of you that have 4 or fewer employees and you had a net income in the previous calendar year of less than $1 million, then you can provide unpaid leave. Of course, you can choose to provide paid leave if you want to, but your obligation under this law is 40 hours of unpaid leave. Let's say you have a really good year this year, and your net income exceeds 1 million next year. You'll have to provide 40 hours of paid leave. It's based on what was your previous calendar year net income. Did that exceed $1 million? For those of you that have 4 or fewer employees and made greater than $1 million in net income, and I have to emphasize net income, this is not gross. This is effectively going to be your income after you've paid all your expenses and those sorts of things. Those of you that have 4 or fewer employees made a net income greater than $1 million, or if you have more than 4 employees, it's going to be 40 hours of paid sick leave. So this is basically what employees are entitled to accrue. If you provide a front load method, you could front load the full 40 hours, or you could have people accrue 1 hour for every 30 worked up to that 40 hours. Once they've accrued 40 hours in the calendar year, they stop accruing. They can continue to use the time, but they're not going to earn any more until the following year. The other thing I did want to mention about accrual. So let's say hypothetically you have a part-time employee, but you want to front load their sick leave balance. You have a couple of options. 1, you front load the full 40 hours if you want to be generous. 2, you can basically work out, what is their anticipated weekly schedule. So let's say you have an employee and you say, okay, I think that they're going to be working 20 hours a week for the 52 weeks. You tally up how much the total number of hours that is. In this case, it would be a little over 1,000. I think 20 times 50 is 1,000. So let's just assume for ease of reference, it's 1,000. Divide by 30. That's the number of sick leave hours that you anticipate that they would earn if they were to accrue. And if you want to front load, you can front load that number. The one caveat is that, let's say you overestimated and they worked less than you expected, you can't take that time away. But if they worked more than what you expected, you have to give them more time. So let's say you front loaded, for example, 30 hours, and you find out that, oh gosh, if they had been accruing, they would have accrued 35 hours. When you realize that, you've got to give them the additional 5 hours. But if you front loaded them the 30 and then they end up working less than you expected, and you realize, oh, well, they really would have only accrued 25 had I used an accrual method, doesn't matter. You've got to let them keep the 30 to be used. Okay, so this, I don't want to bore you guys too much here, but this is just the list of all the qualifying reasons that people can actually take sick leave. Probably the biggest thing to note here is that these are extremely broad. So it includes, not just the employee's actual illness, but it includes family members' illnesses. If the employee has to care for them, this could include, an employee taking a family member to a doctor's appointment. It includes also preventative medical care, both for the employee and the employee's family members. And so from a practical perspective, this could mean an employee who, let's say, they have an underlying medical condition, and they have to go to routine checkups, every few months to, give their doctor an update. It's, get new medication, whatever it happens to be. Those preventative medical appointments are qualifying reasons under the paid sick leave. So if you have an employee call up and say, hey, I've got this doctor's appointment, next week, I've got to go to this. I'd like to take sick time. In all likelihood, that's going to qualify. There's also time related to an employee or a family member being the victim of certain crimes, and those things include domestic violence, sexual offenses, stalking, human trafficking, etc. So this could be, and certainly your policy would outline this in greater detail. But let's say that an employee has been the victim of domestic violence, or maybe their children have been the victim of domestic violence. Any time that they need to spend, say, relocating, moving out of their home, that could be a qualifying reason if they are moving away from a domestic violence situation. Or, for example, if they were meeting with an attorney to discuss, what had happened to them, whether they were, trying to sue their abuser in civil court, or if they were meeting with a district attorney to potentially prosecute their abuser, that also will qualify. The one caveat here is that the employee or the family member who they're taking time for can't actually be the perpetrator of the crime. So as long as the employee or their family member is the victim, then they could take a qualifying paid sick leave time, again, based on their victim status. Okay, so in terms of use, basically, you guys have a lot of freedom here to pick what increment of use you want to use up to 4 hours. So from a practical perspective, what this means, let's say you have an employee who takes, goes to a doctor's appointment and they are absent for an hour. You could certainly, in your policy outline, we're going to use increments of 1 hour. And so that person would use 1 hour of paid sick time. But you could, like I said, pick an increment up to 4 hours. So in that same example, you've got someone who's out for 1 hour to go to a doctor's appointment. If you chose 4 hours as your increment, then they've used 4 hours of sick leave. Same example, but the person is absent for more than half the day. Let's say they were absent for 5 hours from work, but they come in for those last 3 hours of the day. They were gone for more than 4 hours, so their first 4-hour increment is gone. They were gone for an additional hour. That's a second 4-hour increment. In that situation, if you picked a 4-hour increment of use, they're going to use 8 hours of sick leave. And again, you can't pick an increment greater than 4 hours. So what that means is you can't pick 8 hours and make people use an entire day of paid sick leave because they were gone for 1 hour. In terms of how to pay people, this may come up for you guys depending on how you pay your employees, but the statute says regular rate of pay. So from a practical perspective, if you have hourly employees, they earn the same every hour, they're going to earn the same for their sick leave. But if you have things like commissions, or you provide non-discretionary bonuses, things like attendance bonuses, those are going to be factored into their effective hourly rate. And they would need to be paid that on top of their base rate for hours of paid sick leave as well. So it's very similar if you guys are familiar at all with the federal regular rate calculation. But keep in mind, it's not necessarily the exact same calculation because this is New York State's law, and they haven't said you have to use the federal calculation. What they've said is regular rate of pay, and that could include things like non-discretionary bonuses, commissions, etc. You also, when you have employees who are actually taking sick leave, you can request or require they provide you with a doctor's note or an attestation saying that they were absent for a qualifying reason. But you can only do that if they miss 3 consecutive work days or work shifts. So what that means is, let's say you have an employee who calls you up and says, I need to miss, I'm having, knee surgery and I need to be out for 2 days, but I'll be back on the 3rd day. You can't ask them for a doctor's note. You can't ask them to certify that they were absent for a qualifying reason. But if they say, I am having my knee surgery, it's going to take me 3, 4, 5 days to get up and running. In that situation, you can require that they provide you with a doctor's note saying that they were absent and that it was for one of the qualifying paid sick leave reasons. The one exception here is that you can't require they provide you what's called confidential information. And so there are proposed regulations that have come out related to, what is the definition of confidential information in this situation? And what they basically said is you can't ask or require that they provide you information on their diagnosis, treatment, medications that they're taking. What you can basically ask for is this a qualifying reason? Yes or no? And, how long will you be out? When are you going to return? The other thing that this does not implicate is, let's say you have an employee who's out for an extended period of time, for whatever reason. If you want to get them to provide a doctor's note certifying that they're just clear to return to work safely, you can absolutely still ask for that. So if you had an employee, for example, who's returning to work, after having coronavirus, and you want a medical note saying that they're no longer contagious and that they're safe to return to work because they've completed their quarantine, you absolutely can still do that. Okay, so many of you may already have a sick leave policy or even just a vacation policy. And in a way, that's great because if it meets the minimum requirements that I've just talked about, then you can just keep using that and tell all your employees that they're allowed to use that to satisfy their sick leave requirements. So from a practical perspective, that means if they accrue or provided at least the 40 hours of sick leave, and it accrues at least that rate of 1 hour for every 30 worked, you allow carryover year to year, and you allow them to use it for the sick leave reasons. That can qualify. You can use your existing policy. If your policy is not as generous as the sick leave law, though, and you still want to use it, you can tweak your policy, bring it into compliance with the paid sick leave law, and then let people know that they can use that to satisfy their sick leave requirements. We're seeing that this is, some employers like to do that and others don't. It can be onerous that you have to provide all the sick leave law minimum requirements for your vacation time. But at the same time, sometimes it's easier because it means you don't have to provide a new bucket of 40 hours for people to use. I don't know if this would apply to any of you guys, but to the extent that any of you have a unionized workforce, meaning you have a collective bargaining agreement with a union and their employees who are in the bargaining unit and they work for you, you basically can do what the collective bargaining agreement says. If you've signed a new collective bargaining agreement, you can specifically disclaim the paid sick leave law requirements and just say we're doing something else that's comparable and we think that's fair. And if you have an existing agreement that isn't new, hasn't been signed since September 30th of 2020, you can basically reach out to the union and say, hey, we're aware of this. We know our policy is not compliant. Here's what we're going to do to make it compliant, and give them an opportunity, say 10 days, to get back to you if they have any issues before you implement. That way, you're not taking away their opportunity to bargain over something that could be a mandatory topic of bargaining. Probably doesn't apply to a lot of you guys, but wanted to make the note just in case there's any of you out there who are like, oh, what do I do? I've got a union. Okay, just a few miscellaneous things before we wrap up talking about paid sick leave. First off, basically you can't discipline an employee for taking sick leave. That's what this no retaliation for exercising right of use means. So what that means is someone calls in, says they're using sick leave, you can't subject them to your attendance policy, you can't give them a corrective action, you can't write them up, you can't fire them. For those of you that are small enough and have a net income under $1 million, what this means from a practical perspective is that people are going to get 40 hours of unpaid leave. It really just means that they're not coming into work today, and you can't discipline them for not coming in simply because they're ill. Of course, if they're not really ill and they're lying to you and you know that they're lying to you, you can, of course, still discipline them for lying to you about why they're absent. You also are not allowed under the statute to mandate specific notice. So a lot of employers that we work with will say something in their, employee handbook or whatever their policy is on attendance that says, if you're going to be absent today, you have to give me at least 2 hours notice, absent some, extenuating circumstance. You can't do that with paid sick leave. What you basically can do is right up until the moment that they're taking the leave, they can give you notice. So if your workday starts at 9 a.m. and you have an employee that calls you at 8:59 and says, I'm sick, I can't come in today, and they have a qualifying reason, unfortunately, you can't require that they provide you more notice, and you can't discipline them for the absence. Restoration to the same position with the same terms, what that means from a practical perspective is that they get to come back to their exact same job that they left behind. Payroll records have to reflect the amount of sick leave that each employee has. What this means is your pay stubs that you provide your employees should just have a note on it. I don't know if you guys on your pay stubs have like a vacation balance, something like that. You can add one for paid sick leave. And then if an employee comes to you and asks, what's my sick leave balance? You have 3 business days to tell them what that number is. It may take time to calculate, again, especially if you're using an accrual method. But if somebody says to you, hey, gosh, I don't know what my sick leave balance is, you basically have 3 working days to figure out what that number is and get back to them. Just a couple other things I wanted to mention as we wrap up PSL. So there is some guidance from New York State and some proposed but not final regulations that address a lot of the questions that we've had about PSL. What this means from a practical perspective is that New York State is still finalizing how they're going to handle this, and they will issue final regulations that explain all of this. Right now, I think the public comment period either just expired or is expiring. Which gave everybody an opportunity to explain, what they thought about paid sick leave, and if they thought that the regulations were good, bad, if they were indifferent, whatever. So New York State is sifting through those public comments, and they will issue the final regulations over the coming months. But a couple of things, and I think I said this at the outset, you can use for the 12-month period, you can use the calendar year, but you could also use any 12-month period you want. So if you want employees to use this based on their anniversary date, for example, or if you want to use your fiscal year instead of the calendar year, absolutely, you can do that. In terms of accrual, only time that employees actually spend working counts. So that means if someone is taking a vacation, even though they're getting paid, a paid vacation, they do not accrue PSL during that unless you want them to. Basically you have the option, but it's not required. One thing that people thought was a very glaring absence from PSL was bereavement leave. So this does not cover bereavement leave. New York State does not have any bereavement leave requirements. Of course, you can provide more. You can provide bereavement leave to your employees. You have no legal obligation to do that. Again, employees are immediately eligible to take PSL. So as soon as they've accrued any amount of time, it could be 1 hour, it could be 5 minutes. If they've accrued any PSL time and they have a qualifying reason, they're allowed to take that time. Again, I mentioned this earlier, rate of pay. It is their regular rate, so you may need to do or have your payroll company do some sort of calculation to determine what that number is, but it's not necessarily the intricate, complicated federal regular rate number. So it's not the easiest thing in the world, especially if you pay employees on commission or something like that, but it is doable, and luckily you don't have to go through that whole federal regular rate analysis if you don't want to. Again, we've seen new guidance come out. The final regulations are forthcoming, so there may be some things that change over time. And then the final thing here I wanted to mention, like I said, in the regulations, the proposed regulations defined confidential information. And again, this is implicated by if you ask for a doctor's note for someone who's been absent for 3 or more consecutive work shifts. You can't ask for certain information related to their diagnosis, treatment, etc. But what you can do is ask for a doctor's note saying that they were absent for a protected reason and that they're clear to return to work now. Okay, so I'll give you guys, if you have any questions about PSL, feel free to type them in the chat, or if you want to just, turn on your audio and ask a question, feel free to do that. If nobody has anything, then we can move on to New York's specific COVID-19 paid leave law.
Hi, I do have a question.
Yep, absolutely.
Okay, if a collective bargaining agreement has a time frame in which somebody has to call in for a sick time, like they have to call in 2 hours before the start of the shift, does this invalidate that requirement?
If they're calling in for one of the qualifying paid sick leave reasons, yes. And so what I would do in that situation, like I said, is If you recognize that your collective bargaining agreement does not meet the minimum requirements of the paid sick leave law, and that's a great example of a situation where it doesn't, what you can do is basically identify all the deficiencies in the collective bargaining agreement, all the things that don't meet the PSL, outline those in a letter to the union and say, we're going to correct these deficiencies. You don't need to obviously change the collective bargaining agreement, but tell them we're not going to enforce this requirement in the limited PSL circumstances. This is our plan, and you have 10 days to get back to us if you want to bargain over this issue. So that way you're giving them, you're letting them know what your plan is, and you're giving them that opportunity. So you're not denying them the opportunity to bargain over something that, could be a mandatory topic of bargaining. But at the same time, you're basically bringing your policy into compliance with the paid sick leave law.
Okay,
And-
so going back, this would need to be changed. You cannot maintain that call-in requirement
Right.
because that
The-
would be in violation. Okay.
It technically violates the statute. We have seen out of the Business Council, who obviously has kind of an ear directly to the governor. They've said that the Department of Labor doesn't have plans to enforce this law against unionized workforces, against employers with collective bargaining agreements, but they've refused to put that in writing. And especially if you're a little bit risk averse, I would definitely recommend sending that letter and basically telling them you're going to bring things into compliance. The other thing you could do if you have a collective bargaining agreement that is very near expiration is basically wait this out and then address it in the new collective bargaining agreement, which again could just be disclaiming that you're not going to provide the requirements of the PSL. It just puts, especially you guys that have an existing agreement that isn't about to expire and isn't necessarily compliant, puts you guys in an awkward situation where you have to decide, do we want to risk just doing what we're doing, or should we bring things into compliance?
Okay, and this call-in, if you have a combined, like a PTO system with your vacation time, personal sick time,
Yep.
Can you limit again, through negotiations, but is it violating the paid sick leave if you limit the number of days that you can use, that you can have an unscheduled absence?
No, that's totally fine. You would just have to, if someone calls in and tells you that it's for a sick leave reason and they're not lying to you, or you don't have a reason to believe that they're lying to you, in that situation, you couldn't enforce your unscheduled attendance policy against them. But if they just call in and say, I'm not coming in today, and they don't tell you it's a sick leave reason, you have no reason to believe it's a sick leave reason, then you can enforce your attendance policy against them.
Okay, but I'm thinking of a circumstance where somebody, say, accrues 100 hours of PTO time.
Mm-hmm.
And they keep using that as unscheduled absences, but it's over the 56-hour requirement, earnings
Oh, I
requirement.
see what you're saying. So once that 56 hours is gone, even if
Yes.
they call in for a sick leave reason, it doesn't matter. They've used their sick leave time.
Okay.
They're only allotted, in your case, 56 hours. Once they've exceeded that, then you have no obligation to provide them sick leave or any of the protections of the sick leave law.
Okay, thank you so much.
No problem. Does anyone else have any questions before we move on to New York's specific COVID-19 leave law? Okay. I will interpret your silence as not having any questions. So, and you guys have probably all seen this, in March of 2020, Cuomo announced this law that basically said that if someone has an order of quarantine or isolation from a New York State agency, they are entitled to paid leave for the duration of that order. The amount of paid leave kind of varies based on your size, much like the paid sick leave law. And there are some exceptions that we'll talk about here as well. So at the outset, you have to have an order of quarantine or isolation, and it has to be issued by an appropriate department of New York State. So that could be New York State itself, the New York State Department of Health, a local board of health, or any governmental agency that provides you with this order of quarantine. Practically speaking, this means your doctor can't tell you that you have an order of quarantine. It means that you can't decide that you should be quarantined, and you just isolating yourself at home does not implicate this law. There's some guidance that we'll talk about that kind of calls these into question a little bit, and you have to make a business decision as an employer what to do. But the law itself specifically says you have to have an order of quarantine from an authorized New York State agency for this sick leave law to be applicable. A couple of exceptions. If you have employees who you warn ahead of time that if they travel to a restricted state or a country that is flagged by the CDC as level 2 or higher, and they go and they come back and they get an order of quarantine, you don't have to pay them for that time, but you have to warn them ahead of time that their personal travel to a restricted state or country means they're not going to get this paid leave law. And from a practical perspective, this basically means any employee who leaves New York State or one of the contiguous states, meaning a state that shares a border with New York. If anyone leaves New York and it's bordering states, when they come back to New York, they're going to get an order of quarantine. If you warned them ahead of time, personal travel means no pay, then you don't have to pay them for their quarantine time. The other big exception is what we call asymptomatic telecommuters. So these are people who get an order of quarantine, could be for any reason. They don't have any symptoms, they're capable of working, and their job duties can be done remotely, and you let them do their job duties remotely. Those people can do their job at home, get paid for the time they actually spend working, as opposed to getting this paid leave for the quarantine order. Okay, so this is, again, probably the most important thing for you guys in terms of, how do we actually do this? For those of you, smaller, this is a small business talk. So for those of you that have 10 or fewer employees and in your previous calendar year had a net income less than $1 million, you don't have to provide any paid leave. They obviously are going to get the quarantine order leave. You just don't have to pay them during that time, but they can also, to receive some pay, they can apply for paid family leave and short-term disability benefits for the duration of the quarantine order. And you guys probably have seen recently, quarantine orders used to be 14 days. Now, in most cases, they're only 10. So practically speaking, someone could be absent from work from, 6 to 8 days and get some sort of pay. But if you have 10 or fewer employees, net income last year of less than $1 million, they're going to have to go through paid family leave and short-term disability benefits to get that pay. If you have a net income from last year greater than $1 million, or you have more than 10 employees, they're going to get 5 days of paid leave from you. And again, the whole duration of the quarantine order is protected leave, but you only have to pay them for 5 calendar days. That's based on the amount of work that they would have done over that quarantine period. So if they weren't going to work 5 full days, you don't have to pay them for 5 full days. Let's say that this was a part-time person. Over the duration of the quarantine order, they were only scheduled to work 3 days. You only have to pay them for 3 days, but you may have to pay them for up to 5. And then if they were still scheduled to work, after that 5 is exhausted, but the quarantine order continues, again, they can apply for paid family leave and short-term disability benefits. We'll talk about this later. Under normal circumstances, you can't apply for both of those at the same time, but under this limited circumstance, people collect both at once. And then for you larger employers, if there are any on this talk, with 100 or more employees, for the duration of the quarantine order, up to a maximum of 14 days, calendar days, paid leave, unfortunately paid by you guys. From a practical perspective, this probably means that employees are only going to get 10 days of paid leave for a 14-day quarantine order. And then I doubt that there are any of you guys on here, but public employers, so like municipalities, state agencies, etc., also 14 days. For large employers and public employers, it's kind of an open question even now, whether people, if they've exhausted their 14 days of paid leave from their employer, whether they can get paid family leave or disability benefits. I would recommend in that situation, provide the information for applying for those benefits to the employee. Let your provider sort it out, because you don't want to be in the position where you're telling your employees whether or not they'll qualify for PFL or disability benefits, because those are determinations properly made by the benefit provider, not by you guys. And even I don't make those determinations. I try to stay out of it. That way, if we get it wrong or anybody gets it wrong, it's the provider's problem, not your problem. Okay, So I mentioned at the beginning of this topic, there is some new guidance from New York State that kind of calls into question, who can provide a quarantine order, how many times can people get a quarantine order, that sort of thing. So at the end of January, the New York State Department of Labor issued guidance that said that there's a cap on the number of times someone can actually receive paid leave in connection with a quarantine order. Of course, if they get more orders of quarantine, someone who repeatedly is exposed or repeatedly contracts coronavirus or tests positive for coronavirus, they can still get additional orders of quarantine. Theoretically, they could get an infinite number of those, but they're only going to get paid by you guys up to 3 times. So for the first paid leave, it can be for any qualifying reason that they actually receive an order of quarantine. So if an employee tells you, I got an order of quarantine, you say, let me see a copy. They show it to you, you give them the paid leave. The second and third time, they can only get the paid leave if they received an order of quarantine for a positive COVID test. So practically speaking, let's say you have an employee who already got a paid leave for whatever reason, they got an order of quarantine, doesn't matter the circumstances, but they got the order from the local Department of Health, they get that first paid leave. Second time, they tell you, I've got an order of quarantine, I was exposed. They don't get paid in that situation because they don't have a positive test. Same thing with the third one. Exposure, not a positive test. They still get the leave, they don't get paid. Of course, they could apply for short-term disability or PFL benefits. Again, you just provide them the information to do that, let your provider sort out whether they're eligible. Fourth time that they get an order of quarantine, doesn't matter the reason, no pay. They get the leave for the duration of the order of quarantine, let them apply for PFL, disability, whatever, but you don't have to pay them for those 5 or 14, whatever those days were. The guidance also mentions that employees who continue to test positive, even if they don't get a new order of quarantine, the guidance says that they have effectively gotten a new order of quarantine, they get another 10 days. This goes above and beyond what the statute says, much like some of these next couple of things do, and we'll talk about the implications of that. The next thing is that if you get a positive COVID test, this guidance says that that's the equivalent of an order of quarantine. And the guidance also says that for you employers who, let's say you have an employee who has symptoms, you tell them to get tested or you keep them out of work because of an exposure, potential exposure, whatever. The guidance says that they are supposed to be paid for that time, even though it's not really an order of quarantine. This creates a problem for actually providing the paid leave for a couple of reasons. First and foremost, the statute explicitly only says that people get an order of quarantine from a local Department of Health, State Department of Health, New York State, or an authorized government agency. So all of these situations, we're talking about bullets 2, 3, and 4 here. Those are situations where the Department of Labor has tried to tack on an additional requirement, an additional pay requirement that the statute doesn't authorize, and they may or may not have the authority to do that. So this new legal obligation that they say is related to the statute, but isn't included in the statute, creates a question for you guys as to whether or not, practically speaking, you want or even can provide paid leave in these situations. So, unfortunately, I can't give you a definitive answer of how to handle this, but I can tell you it's a business decision on your part. Do you want to risk deviating from the guidance because potentially the New York State Department of Labor or the Attorney General's office could come after you and say, you didn't follow this guidance, you were supposed to be paying your employees in this situation. And then you have to argue with them and say, well, no, you went beyond your authorized ability, beyond your authorization in the statute to actually require pay in the situation. Then you have to duke it out, fight in court. This did happen related to a different statute, the FFCRA, we'll very briefly mention in a couple minutes here. And the court in that case said the guidance went beyond what the statute said. You don't have to follow it. That hasn't happened yet with this guidance. So you guys have to make the business decision. Are we going to follow it or are we going to deviate? And if we deviate, we're obviously taking the risk that the Department of Labor or the AG's office comes after us. We have to duke it out with them in court. We may or may not win that battle. On the other hand, if you provide the paid leave, this additional paid leave that the Department of Labor says you have to, that could be an extreme burden, especially on small businesses, that you're paying people to not work in a situation above and beyond what the law actually said that you had to provide. So, like I said, unfortunately, there's no, one size fits all approach to this. You guys have to make, unfortunately, a business decision for how you want to handle this. Okay, I'm going to briefly mention paid family leave. There's just a couple of quick updates that I want to just flag for you guys, but not necessarily a lot of updates related to paid family leave. Probably the biggest thing is that paid family leave, they kind of expanded the definition of when someone could take it to include individuals and their minor children who actually are subject to an order of quarantine. So if someone gets an order of quarantine, then they could get paid family leave benefits. We mentioned that very briefly as kind of a supplement to the New York State paid COVID leave. It only includes minor dependent children as family members. So this doesn't include spouse. It doesn't include a lot of the extended family that you might normally be able to take family leave benefit time to care for. But the same weekly benefit up to the $840.7 per week, that's the same. And technically, there's no cap on the number of weeks that you could collect this benefit as long as you have a qualifying reason. Same is kind of true of short-term disability. They expanded it to allow people who are subject to an order of quarantine. And again, no cap on benefit weeks, and the benefit cap is the same. The other big caveat here, and I mentioned this earlier, under normal circumstances, people cannot receive short-term disability and paid family leave benefits at the same time. But under the very limited circumstances where someone is subject to an order of quarantine, they can. And they can get up to $2,043.92 per week. And again, there's no cap on the number of weeks they can do that as long as they have a qualifying reason to do that. So if you have somebody who tested positive or was exposed, whatever, they got an order of quarantine, they've either exhausted their leave through you guys, whether it's the 5 days, 14 days, whatever it happens to be, or you're not obligated to pay them at all during that time. Always, always, always provide them the information to apply for short-term disability and PFL. The other thing here, just wanted to briefly mention, the employee contribution rate increased. Luckily, even though it increased pretty significantly, it does not require contribution from you guys. It only requires that you take it out of the employee's paycheck to pay into the PFL benefit. So you guys don't have to pay for it, but there is an increase in the dollar amount of what has to be paid towards PFL benefits. Because fundamentally, PFL is an insurance policy that New York State requires every employer with at least one employee in New York to have. Okay. This, I won't bore you guys too much because I see that I have grossly underestimated how much time we have. This is just a list of topics that if you have a PFL policy, I strongly recommend that you include in your policy. If you don't have a PFL policy, I strongly advise you to get one, to put one together, and that it should include these topics. Okay. So FFCRA, we'll talk about very, very quickly because, good news, it expired. So this came into effect April 1st of 2020, expired December 31st of 2020. There was a voluntary extension. If you wanted to continue to provide the paid sick leave and FMLA expansion time to your employees, you could voluntarily do that through March 31st, 2021, and continue to receive payroll tax credits for the time that you pay out. Not a requirement, totally voluntary. And again, technically the statute expired on December 31st, so you can absolutely ignore it from here on out as long as you complied April through December of last year. So like I said, there was an emergency paid sick leave and an emergency FMLA expansion. This, in all likelihood, applied to you guys, the FFCRA at the time, because it applied to all employers with 500 or fewer employees. There was a limited exception for employers with 50 or fewer people. who it would have been a great burden to let your employees take this leave. You didn't have to comply with it. Again, this is expired, so no need to concern yourself with it too much. But if you wanted to be one of those employers that voluntarily allows employees to take this leave and get the tax credit to pay for the time that they were out, these are 3 of the 6 qualifying paid sick leave reasons. Again, I won't bore you with it too much, but it's basically if someone got COVID, had an order of quarantine, or their doctor told them they had to self-isolate, that sort of thing. There are 3 more reasons. These reasons are a little bit different. It's basically related to caring for someone else who either has COVID or their school was shut down due to COVID, and there was a lower dollar amount of pay that employees were entitled to under these 3 reasons as opposed to the first 3. And then there was an expansion of FMLA that allowed people to take up to 12 weeks of partially paid time if they were caring for a minor child whose school or daycare was closed due to COVID. Again, totally voluntary, whether you want to continue to provide this now, but almost all of 2020, this was mandatory. And if you want to keep doing it now through the end of this month, you'll still get the benefit of the tax credit. So trying to gloss over this again, because it's purely voluntary. You have no obligation to do this, but I wanted you all to be aware that if you have employees who have qualifying reasons and you want to provide them with the paid leave, you can still get that tax credit through the end of March. Okay, so some actually good news on unemployment benefits. Basically, in mid-January, the Department of Labor issued an order that said we are canceling all the unemployment benefit charges that we imposed against employers' accounts. So this applies to any of you guys that are nonprofits that are self-insured and actually pay out of pocket for unemployment benefits. It applies equally to those of you that pay unemployment insurance taxes and have an experience rating. So basically, they decided due to the pandemic, there were an extreme number of claims. We're removing those from everybody's account. We're applying them to the general account. So those of you that were self-insured nonprofits, you will get reimbursed for every dollar that you paid between March 9th until this order is rescinded. Any new benefits, they're not going to make you pay. You're still going to get your quarterly bills, but it'll either have an insert or tell you don't pay. And for those of you that participate in the normal unemployment insurance tax system, basically your experience rating won't go up, and that means that your tax rate shouldn't be impacted, or at least not drastically impacted. And this continues until further notice. So until the Department of Labor rescinds it or a New York state of emergency ends, this continues. Okay, the other thing I wanted to mention about unemployment benefits is that we're seeing a lot of fraudulent claims. So I would strongly encourage you, even though you're not technically paying for it, continue to monitor your monthly statements for unemployment benefits. Make sure that all the claims on there are legitimate, not fraudulent. If they are fraudulent, report it. And one of the things that we're seeing, it's extremely common. Basically, fraudsters are able to, using the dark web, get people's social security numbers. And that's all you need to apply for unemployment benefits is someone's social security number. They apply for benefits and they divert the cash to a different bank account, not the individual's bank account. And so people are doing this for individuals, any social security number they can get, irrespective of whether that person should be entitled to unemployment benefits. In many cases, companies are seeing people listed as receiving unemployment benefits who still work for them and are working full time. So absolutely monitor your monthly statements, make sure that there are no fraudulent claims. And if there are, report them for a lot of reasons. One, you don't want this fraudster to walk away with that money because ultimately we all have to pay for it in New York State taxes. And 2, if DOL rescinds the order and you didn't contest the charge, it's possible that you would have to pay for it from that point forward, even if it's not a legitimate charge. And someone just typed in the chat, can we get a copy of your PowerPoint? I think we already, I know the Government Law Center was going to distribute to everyone who registered for the event. So if you don't have it already, you should be receiving a copy. Okay. I'm going to try and do this as quickly as I can because we've got about 10 minutes left and I want to give you guys an opportunity for questions. But I wanted to talk about some reasonable accommodation issues because this is something that I think a lot of people don't necessarily know how to handle. And it's kind of a whole new world out there with how do we handle employees who have health conditions and are impacted by coronavirus. Okay, so first off, I wanted to mention the FMLA. It only applies to employers with 50 or more employees who are working within a 75-mile radius. So for every work location that has at least 50 people in a 75-mile radius, it applies to all these people as long as they've worked for a year and they've worked at least 1,250 hours in that year. For you guys, as small businesses, this probably doesn't apply to you, but that doesn't mean that you don't have to provide paid or unpaid leave to people, depending on the situation. If someone did apply and qualified for FMLA, they would get up to 12 weeks of unpaid leave. But most applicable to you guys are the Americans with Disabilities Act and the New York State Human Rights Law. So ADA applies to all of you that have at least 15 employees. The Human Rights Law applies to all of you if you have any employees at all. And what it basically does is if somebody has a disability, they may be entitled to some form of accommodation, and that accommodation could include a leave of absence, unpaid leave of absence. So to qualify as having a disability under the ADA, someone has to have a physical or mental impairment that substantially limits one or more of their basic life activities. And this includes if they have just a doctor's note saying that they have, this sort of impairment. It's a very fact-intensive inquiry whether someone has a disability because the same medical condition could impact different people differently. So there's a lot of case law out there saying, is this a disability? Is it not a disability? But basically, if somebody has a bodily function or like a daily activity that is impacted by their medical condition, it's probably a disability under the ADA. I have a case right now, somebody has psoriatic arthritis and psoriasis. Those are obviously related conditions. And they've said that that is their disability. That's the thing that impacts their daily life. Under the New York State Human Rights Law, it's a much broader definition. So basically, if you have a doctor's note saying that you have any kind of impairment, physical, mental, neurological, etc., that's going to qualify as a disability. And that could mean, like I said, providing an individual with some sort of accommodation. So it's a very, very fact-intensive inquiry. So anytime that you have someone comes to you and says, I have this condition, I need something in order to fully perform my job, you basically have to decide, is that something that I can provide? Because first off, you don't have to eliminate an essential function of someone's job. So, let's say hypothetically, you've got a truck driver, a UPS driver, they're delivering packages. If they can't lift things to bring, that package from the truck to the door, or to load the truck, unload the truck, whatever, in all likelihood, that's an essential function. You don't need to provide them something that prevents them from having to lift those objects. But it might be something small. Let's say you have an employee who, I had a case like this. An employee had an allergy to certain chemical irritants that are in perfumes. And so what we basically had to do was say, okay, we'll do our best. Obviously, we can't guarantee, but we'll do our best to provide you with an environment where people are not wearing perfume. And so that was, at the outset, we're just telling everybody in the office without disclosing specifics, can you just don't wear perfume? Please do not wear perfume to work. It could be very simple like that. Just asking everybody, don't do this thing because it impacts one of your coworkers. The Equal Employment Opportunity Commission came out with some new guidance. I've got a link here. I would strongly encourage you all to read it. It just covers a bunch of topics that I think are implicated by coronavirus. So things like telework, even though many of you probably were operating your business 100% remotely previously, that doesn't mean that if somebody comes to you and says, I want remote work as an accommodation, you're not guaranteed that you have to provide that. For older employees, employees over 65, anyone over 65 is at a greater risk of severe complications for coronavirus. If they were to contract it, their symptoms would be much worse, potentially lingering impacts, things like that. But age is not a protected characteristic that requires accommodation. So you could choose to provide someone with an accommodation based on their age, but you're not legally obligated to. Things like delays in the interactive process. So the interactive process is when someone says to you, I have a disability, here's what I need. And you say, okay, well, here's what we can provide. You go back and forth till you figure out the thing that you can provide them. There may be delays in that, just practically speaking, related to coronavirus, remote work, et cetera. Basically, you just want to do this as quickly as is practical under your circumstances. Don't ignore people's requests, but at the same time, if you can't get to them immediately, that's okay. So I would just strongly encourage you all to take a quick look at that. We'll very quickly talk about remote work. The big takeaway from remote work is just that I strongly encourage you, if you have employees who are working remotely, implement a policy, have a remote working agreement that outlines all of your expectations, and hold people to that. So basically, there are a handful of areas of concern, things that are impacted by remote work. The duration of the remote work agreement, what the working schedule is, how people are going to record their time, how often they're required to communicate with their boss, with their coworkers, and how your normal workplace policies are, how they are impacted by your normal workplace policies. So I will just give you guys a quick overview of those things, and we can probably skip a few slides because I want to be respectful of your time. Basically, if you have an employee who comes to you and says they want to work remotely, I would outline in a remote work agreement how their working schedule is going to be and the duration of their remote work arrangement. And that could be it continues until we say otherwise. It could be a specific period of time based on a specific reason. But you just want to make sure that people understand, this is how this works. These are the days that I'm going to be remote. These are the days I'm going to be in the office. And I should be available from, 8 a.m. to 5 p.m. Those are the times that I'm working, and I shouldn't be attending to other things. In terms of timekeeping, the U.S. Department of Labor came out with some guidance recently that basically said any time that employees spend working, whether you authorize the work or not, is compensable. So if you have an hourly employee who does work, they absolutely need to record that accurately. You can obviously discipline them in another way for working when they weren't authorized, but you absolutely still have to pay them for the time that they spent working. So anytime that they choose to work for you, even if it's not authorized, pay them separately, discipline them. Communication, I would outline that they have to, whether it's talking to their boss once a week or this coworker once a day, et cetera. You want to basically outline how often they should be communicating with their employees, what the expectation is, so that you don't have an employee who just goes off, does their thing, you never hear from them again. And then application of workplace policies, you just really want to remind and reinforce everyone so that they understand that just because they're working remotely doesn't mean they're not bound by the normal workplace policies, meaning that they shouldn't be, sending harassing IMs to their coworkers, that sort of thing, reminding them that all the expectations that they would have at the office still apply, even though they're working from home. So, no drinking during working hours. You shouldn't have any, illegal drugs. You shouldn't be harassing your coworkers via instant messaging. I know these sound very obvious, but you would be incredibly surprised the things that come across my desk. If you just say it at the outset, hopefully it doesn't happen. But if it does, you always have that to point back to and let people know this is why we've disciplined you. This is why we fired you, etc. So I will skip over a lot of these, but basically the takeaway is if you have employees who are working remotely, I strongly encourage you to have a written remote workplace agreement that applies to each individual who's working remotely to establish the expectations that you have and that they have, so that if somebody doesn't meet them, you always have that to point back to and say, this is what you're supposed to be doing now, or, this is why we had to let you go. One thing that I just wanted to mention in terms of eligibility for remote work, certainly you could include your own objective criteria, but if somebody has a disability and they ask for it as a reasonable accommodation, that can kind of trump what your normal eligibility requirements are. That said, you still want to evaluate, is it possible for them to do their job remotely? Are we going to be eliminating an essential function? Is there an alternative accommodation that we can provide that's going to be equally effective? You still go through that process, even if it's someone who comes to you and says, I have a disability, I would like a remote work schedule. Because even though your employee may have worked remotely at some point during coronavirus. That doesn't mean they're guaranteed a remote work arrangement now, even if they have a qualifying disability. Okay, I'm going to really quickly go over these. I mentioned the remote work guidance, so I won't go over it again. Workplace shutdowns, something that happens less now, but I just wanted to very, very quickly mention for your hourly employees, your non-exempt folks, if there's a workplace shutdown, very simple. They didn't work, they don't get paid. For your exempt folks, technically, they're entitled to be paid the same every single week, irrespective of how much they work or how little, as long as they work at all. So if you shut down for part of the week, they still have to be paid in full for the whole week. Of course, you can subtract from their PTO anything else that they may have, any paid leave time to cover it. But they still have to be paid in full for the week, even if they only worked a day, an hour, whatever it is. Big question we've been getting a lot. Do I have to pay employees for the time that they spend completing a health screening? The answer is probably not. No judge or court has addressed this specific issue, but in other cases, and this is an example here, there was a case involving Amazon. The employees were required to go through basically security checks, making sure that they weren't stealing anything, and it was after they clocked out that they had to go through this security screening to make sure that they weren't stealing any products on their way out the door. And the court said this is not an integral, indispensable part of their job. It's just something that you're doing on their way out the door. The same is likely true for health screenings. So all of you, as part of your reopening plan, the thing that I didn't talk about today, should be requiring your employees to fill out a health screening. And if they are, in all likelihood, they don't need to be paid for that time. It should be a negligible amount of time. When I do my health screening every morning before I come in, it takes me all of 15 seconds. But for people who are taking up to 5 minutes, it doesn't matter. In all likelihood, you don't have to pay them for that time. Okay, finally, I just wanted to remind you guys, if you do have salary employees, absolutely make sure that you've gone through the appropriate process to make sure that they're eligible to be paid a salary and that they are not supposed to be paid hourly, because the implications of getting this wrong are huge. If someone worked overtime and they were paid a salary, but they should have been paid hourly with overtime, you can be on the hook for not just the underpayment, but also liquidated damages and attorney's fees. I have a bunch of cases that deal with this exact issue. Basically, salary basis, you want to make sure that they're paid the same every week, irrespective of how much they work, as long as they do work. Salary threshold, there are some new numbers for how much they have to be paid, and that's on the next slide. I'll just have it there for your reference. And duties, they have to meet a particular duties test. These three are the most common ones. So if you have salaried employees, absolutely make sure that they meet these three requirements: salary basis, salary threshold, and that their job duties, their actual job duties that they perform day to day, meet one of these main requirements, main duties tests, or a different one. There's a lesser known. There's highly compensated employees. There's some that are under federal law for truck drivers and things like that. Employees who perform sales functions inside and outside sales, there's different exemptions for those as well. But just absolutely make sure that you've gone through this process. And these are the salary thresholds under federal law. This really only implicates those of you who are using a professional exemption, because under New York law, there isn't a minimum salary that you have to pay professionals. So like attorneys, engineers, people who have a professional license to engage in a certain job. In New York, they get paid the federal minimum here, this $35,000 a year or more, in order to be exempt. If they fit one of the other exemptions, based on where they are located in New York, there's a different salary threshold. So in New York City, it's $1,125 a week. In Nassau, Nassau, Suffolk, and Westchester, it was $975 a week. For 2021, it's $1,050 a week. And for 2022, it's going to be $1,125 a week. In the rest of New York State, anything that's not New York City, Nassau, Suffolk, or Westchester counties, last year it was $885 a week. This year, it's $937.50 per week. And again, this applies to administrative and executive exemptions. Professional, use the federal $35,000 a year number. Okay, so I'm sorry, I know I went over. Had a lot to cover, but if you guys have questions, feel free to type them in the chat, and I can leave a few minutes for you guys right now. I can stick around to answer any questions. And if something occurs to you next week, tomorrow, whatever, feel free to shoot me an email.
Okay, we're way over, so we probably don't have time for very many questions. Are there any at this point? Hearing none, let me thank Paul for wealth of information. Certainly those, you've got a lot to think about. You've got a lot of new information, I'm sure. But if, this, at least it gives you the opportunity to think about all of these issues. If they arise, at least you should be aware of the issue. I think you will be after this presentation. And if you don't have every detail, we can come back and check on that later. So with many thanks, Paul, you've really given people a lot to think about. Much, much appreciated. And we thank you for the presentation.